This case starts like many others, but spirals fast. A defendant rejects his own legal identity, challenges the court's authority, and turns a routine proceeding into a full-blown standoff. What begins as a fleeing and eluding charge quickly becomes a clash between courtroom law, personal belief, and judicial power. Pay close attention, because every word here matters, and one decision by the judge will completely change where this case is headed.
Don't talk to him. Court calls the case People versus Thomas Styron.
I'm Stein, the living man. I'm here by special appearance to address this matter.
I'm sorry?
So I'm Thomas Styron, the living man, not Thomas Ulrich Styron, the entity you know me as, or as I'm in my papers. I'm here to address the matter.
All right, thank you. Wish to be represented by an attorney, sir?
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Now. Mr. Allen. If you don't want to cooperate and handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me?
No.
Not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate. Yeah, I need an interpreter for the last two and that one.
May I swear the interpreter?
Yes, is it for the last two cases?
Yes.
Yeah, that one we'll swear in.
I am Tariq Tariq Kade, the executor of the Tariq Tariq Kade Living Trust and the registered owner of the Tariq Tariq Kade Ex Relatione Kingdom Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the third degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role.
How what?
How religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No,
so I do have.
sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion, yes.
Pardon?
Under threat, duress, and coercion, yes.
No. Not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
With the court, ask the people to prepare the order for the competency.
Yes, please prepare the order for that. Is that your address, sir?
Excuse me? That's correct.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? If I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I
the
did.
court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what
additional
you
week.
stated at the last hearing.
Well, you
You
actually,
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna
That's in-
figure out something. We're playing by my rules, not yours. So you do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go.
I
What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
What we just witnessed is a textbook example of how courtroom procedure collides with so-called sovereign citizen style arguments, and why courts respond the way they do. From the very beginning, the defendant makes a deliberate attempt to separate himself from the legal identity recognized by the court, repeatedly referring to himself as a living man rather than the named defendant on the case. That distinction may feel philosophical or symbolic to him, but legally, it carries no weight. Courts operate on jurisdiction, statute, and identity as defined by law, not personal belief systems. The judge immediately establishes control, and that's critical here. Notice how patiently the court explains the charges: fleeing and eluding in the third degree, a felony punishable by up to 5 years in prison, significant fines, court costs, and even the loss of driving privileges. This isn't minor traffic court. It's serious criminal exposure. And yet, despite those clear explanations, the defendant repeatedly refuses to give a direct acknowledgement of understanding, choosing instead to redirect the conversation toward religion, indigenous rights, and international declarations. Here's the legal reality. While freedom of religion is protected, it does not exempt someone from complying with courtroom procedure or state criminal law. The judge makes that distinction crystal clear. Michigan courts are governed by Michigan statutes and Michigan Supreme Court rules, not international declarations or personal interpretations of sovereignty. When the defendant insists otherwise, the court doesn't argue philosophy. It returns to procedure. And that's where this case takes a critical turn. At multiple points, the judge gives the defendant opportunities to clarify whether he understands the process, not whether he agrees, but whether he understands. That difference matters. Understanding is a requirement for competency. Agreement is not. When the defendant repeatedly says he does not understand basic procedural rules, despite extended explanations, the court is legally obligated to pause and assess whether he is competent to proceed. This is not punishment. It's protection. A competency evaluation exists to safeguard the defendant's constitutional rights. If someone cannot understand the nature of the proceedings or assist in their own defense, the court cannot ethically or legally move forward. That's why the judge orders a forensic evaluation, schedules a competency hearing, and continues bond. It's also why the defendant's attempts to condition his cooperation by claiming duress or demanding reciprocal evaluations are firmly rejected. Defendants do not dictate terms to the court. Another key moment comes when the defendant attempts to file motions late and challenges procedural deadlines. Courts rely on rules for fairness and efficiency. Missing deadlines has consequences, and once competency is in question, the court cannot even hear substantive motions until that issue is resolved. That's not personal. It's procedural law doing exactly what it's designed to do. So what are the big takeaways here? First, courts will always prioritize structure and jurisdiction over ideology. Second, refusing to engage with the legal process doesn't stop the process. It redirects it. And finally, competency evaluations are not insults or punishments. They are safeguards that ensure justice is carried out lawfully and fairly. Now, here's the question for you. Do you think the court showed patience, or should this have been shut down even sooner? And if you were the judge, how would you have handled this interaction? If you found this case as shocking and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns that cut through the chaos and explain what really matters when the gavel comes down.